Hi everyone. The next subject I want to talk to you about, again in broad, pretty kind of sweeping terms, is the issue of federalism, which is the term that we use in constitutional law to define the relationship between the federal government and state governments. And state governments, of course, includes subdivisions of states. You know what those are. So I'm going to talk about three different issues that implicate federalism that you should be ready for. I have seen questions on these and model answers on these issues from past bar exam essay questions. First, let's talk federalism generally. The U.S. government, the federal government, is a government of enumerated powers. These are buzzwords that I would be prepared to throw around right when you see some kind of common law question. Most of those powers that are enumerated, of course, are enumerated in Article 1, Section 8 of the Constitution. So that's the federal government. State governments under the 10th Amendment have police power. So state governments are not governments of enumerated power. They're governments of general power. You would define, again, if you see the state doing something and you're asked whether the state has the power to do that, you certainly would define police power, and that, of course, is the power to regulate for the health, safety, and general welfare of the population. So that's the general framework. Each is sovereign in its own sphere of jurisdiction or authority. So the first specific topic I want to talk about under federalism is anti-commandeering. While it's okay for the federal government and Congress in particular to incentivize or induce or encourage states to enact certain laws or policies, the federal government is not allowed simply to command states to pass certain laws or enact certain policies. So you'll recall, for example, a case we studied where the Congress was telling states that they had to take title to waste. There was a more recent case where there was a law on the books passed by Congress, the federal government, that required states to essentially ban the practice of betting on amateur sports. So those are cases where the Supreme Court said you're not inducing states to do something, you're flat out commanding them to do something, and you don't have the power to do that because both levels of government are sovereign. Furthermore, please remember the Printz case, P-R-I-N-T-Z, in which the Supreme Court said or laid out what we call the anti-commandeering rule. And that is that the federal government cannot commandeer state officials. Usually that's going to be law enforcement officials, right? So if you see a fact pattern where the federal government passes a law, Congress passes a law, and they say this law is going to be enforced by local law enforcement, that is called commandeering and is not permitted under the Constitution. So that's the first specific subtopic under federalism is anti-commandeering. And again, keep in mind, Congress may not command states to simply enact certain policies. We'll get to how they induce or encourage states to do that in a minute, but they cannot flat out command them to do that, and they cannot reach down into states and commandeer state officials to enforce or execute federal law. The second subtopic I want to talk about is the issue of intergovernmental immunities. Again, using buzzwords here, you really want to make sure you're comfortable with these. Here, again, why does this fall under federalism? Because the question is, under what circumstances is a state immune from federal regulation or tax or fees or anything like that? When the state A, when can state A say, we don't have to follow these federal regulations, or we don't have to pay that federal fee because we're a state, and if we were paying a fee to the federal government or following a federal regulation, we'd be ceding, C-E-D-I-N-G, our sovereignty to the federal government. Remember the simple rule here. It's a little bit of a brain teaser. Generally speaking, and I've actually seen in at least one model answer the term generally applicable law. If Congress passes a law or imposes a tax or a fee that is generally applicable, in other words, it doesn't target states in particular, right? It applies to everybody across the board. If you're talking about one of those kinds of laws that does not target, quote unquote, the state as a state or states as states, then the rule is quite simple. The state has to comply with the regulation or pay the fee or whatever the case may be. So, for example, if the state employs people The state has to follow federal regulations about labor standards. You'll remember a Massachusetts case about fees charged for aircraft. And the Supreme Court said, well, if the fees are charged to everybody, not just state aircraft, but anybody who owns and operates aircraft, you have to pay it. It's kind of a rare situation where you would see the federal government targeting states as states. Does happen occasionally, like the cases I talked about before with the anti-commandeering, right? Telling the state as a state that you have to take possession of something, why? Because you're the state. To tell a state that you have to enact a certain law because you're a state, right? That would be an immunity problem. If there was a federal tax that applied only to state-run aircraft rather than all aircraft, that would be a problem. Remember the New York mineral water case, right, where New York is selling mineral water and has to pay a tax on mineral water. The court says, well, if it was a tax on New York mineral water or state-sold mineral water, that would be a problem. But you want to probably err on the side of looking for a law that's generally applicable, right? A state's getting caught up having to pay a tax or follow some regulation, not because it's a state, but because it's doing something that is regulated or taxed by, right, and with regard to anybody who's doing it. So anti-commandeering, number one, the related issue of immunity, number two. Finally, when it comes to federalism, I'm going to talk about the spending clause. Now, spending is an interesting creature because it's both a power of Congress, it's an enumerated power of Congress, but it also involves states. Why? Your typical spending question, the red flag fact pattern that would trigger a spending clause question is what I call Congress trying to bribe states to do something. Now, don't use the word bribe on bar exam, okay? That's going to get you in big trouble. Use the words induce, incentivize, encourage, right? When Congress is trying to encourage states to do something. When that's the case, you have to apply the rule from Dole. And right, that's the case where Congress wanted states to raise the drinking age to 21. In Dole, there are five components of the rule you need to look at. Number one, with any spending measure, under the text of the Constitution, the spending has to be for the general welfare. But please remember to apply that liberally. If Congress is spending money for the benefit of old people, for the benefit of kids, for the benefit of college students, courts are quite liberally going to say that that is for the benefit of everybody. But that's the first thing. So you would look at that, who's benefiting from the spending measure, and does that comport with the requirement that it be for the general welfare. Now we get into the ones that really have to look for problems. Unambiguous. If Congress is going to try to encourage states to do something, it has to induce them to do something. It has to be unambiguous about what it wants them to do and unambiguous about what they stand to lose if they don't. That was met in the Dole case because there was nothing hard to understand about what Congress wanted. They wanted a drinking age of 21. It's very concrete. And what the states stood to lose was 5% of their highway money. That brings us to the next element you need to look at, which is some rational or reasonable nexus between Congress's policy objectives and the spending that it is threatening to withhold. Again, in Dole, you look at what was the policy objective of having states increase their drinking age to 21. The Congress was able to argue, the lawyer for the United States was able to argue that Congress's policy objective there was to reduce drinking and driving, highway fatalities, highway accidents, things like that. So it made sense. It's rational that they would withhold highway money. You can imagine when this would become a problem, right? If I'm Congress and I say I want you to change your drinking age to 21, and if you don't change your drinking age to 21, I'm withholding 5% of your veterans' money. That doesn't make any sense. There's no logical relationship between the policy objective of raising the drinking age and the spending on veterans. The next one I think is a big one, and that is that the measure cannot be coercive. To repeat, you may encourage or induce or incentivize states to do something, but you're not supposed to be coercing them, forcing them to do it. So recall that the court said in Dole 5% of highway funding is merely an inducement, right, an encouragement. But in the more recent Sebelius case, when Congress withheld 100% of states' Medicaid money if they didn't have health exchanges, the court said obviously that is coercive. So you're looking for an amount that is not coercive but is merely an inducement. Finally, and this is kind of a throwaway, Congress cannot incentivize states or induce states to do something that's otherwise unconstitutional. That would violate people's constitutional rights. I doubt that's going to be too much of an issue on these questions. So that's federalism issues to look for in a nutshell. We're talking here about the substance, not just process. The first few videos were about threshold questions to look for, 11th Amendment standing, and state action. Now we're talking about the nuts and bolts. Once you get past all that, if you have some kind of claim involving a conflict between the federal government and state governments and who's supposed to be doing what, the big issues there would be, again, anti-commandeering, intergovernmental immunities, and potentially the spending clause. So get those down, be ready to talk about those issues, and if one of those is an issue, I would use the word federalism. We'll see you for the next one.